Hey, what's up, my new Standard Nation? It's TJ with Strategic Real Estate Experts, and today we're going to talk about how you can and how maybe you should hold title when you purchase a new house. So this is probably super boring, but it's super important. And it's super important that you understand how you can hold title and how you set that up when you purchase your property. Because the fact of the matter is, there's people that are out there that we live in a society, unfortunately, that wants to sue for everything. So your house could be up for grabs if something bad happens to, let's say your spouse has their own business, or you drive and hit somebody, and the way you hold title to your house is not protected. It could actually be forced to be sold so that you can pay previous debts. So how you hold title is super, super important when we're talking about, when you buy the house and how you're going to title in your name. So there's a lot of different ways that you can. For single individuals, there's not quite as many for you. You might think about a limited liability company. You might put it in a trust. So we're going to talk about a bunch of different trusts. But when you're single, there's not quite as many options. Married couples or people that are buying property together, there's a couple different ways for you to do that. So the first one is joint tenancy. So that's where you're both going to own an equal share in the property. And then again, depending on how you have it set up, when one of them dies, it reverts to the other party and however that person's estate was set up. So a lot of this I'm going to revert back to and say you should talk to your estate attorney or an estate planner on what is best for your specific situation. I know for me, what the best way and right way is to take title, but that doesn't mean that's right for everybody else. So you have to think about where you are in your life and where you're at with the assets you do have, especially if you hold a lot of real estate. One of the other ways that people hold title is it's called tenancy in common. So that's actually where people own a certain share of the property. So it could be you own 40%, your brother owns 40%, and your in-laws own 20%. You can all use the property in its entirety. It's kind of like a stock almost that you could sell your 40% or 20% if you wanted to. But again, it's just a different way of holding title. There's a tenancy by entirety. So again, I'm looking down just because I made some notes because I want to make sure that I say all of this stuff properly and right to everybody. But this one is not used quite as much, but it's going to be, it's similar to joint tenancy, but it has rights of survivorship, but it's only available to married couples and people in civil unions. So again, the biggest way to plan for the future, and what most people do, is they talk about trusts. So there's a couple different kinds of trusts that are out there for you. You have land trusts that are out there, not quite as big anymore. It used to protect people from seeing who the property was going to, but the curtain has been kind of unveiled on that, and when a property is transferred after a death, we kind of see who that goes to. So land trusts aren't quite as big anymore. We have qualified personal residence trusts. So this one's super interesting. Is going to be for people that are way later in life, and what happens is, this is one that you do for tax implications, but if it's a property that you put into this, it's a QPRT, Qualified Personal Residence Trust. You actually live in the property for 5 years, and little by little, some of that property is transferred to your heirs, and then after 5 years, you're renting it from them. And then when you pass, there's a lot less tax implications involved. However, if you die before that 5 years is up, you basically paid an attorney to set something up that you didn't get to take advantage of. You have living trusts. So a living trust, you can put stocks in, real estate in, and it's more estate planning purposes. You see a lot more people doing a living trust, at least around here. You have family limited partnerships, and again, those aren't... People use all of these. I don't see the family partnership quite as much, but the living trust is pretty big as far as protection and estate planning. And then the biggest thing that you have to look at is in Wisconsin, and this is not everywhere, okay? So it's a community property state. So what that is, there's a few states out there. It is Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin are all community property states. So what that means for you is you get married and you own the house in your name before you got married. Automatically those states look at like anything that you bought during the relationship was 50-50, even if it's just in your name. So that spouse is going to get 50% and 50% will go toward your estate. So if your spouse gets all of your estate, obviously they get the whole house. But just know, you have to know what state you're in, the implications for if you still own that property in that state, but then you move to another state. There's a whole lot of stuff that you need to think about before just buying the house and going, oh, okay, we're going to take it in our own personal name. Most of the time, nobody ever asks you about this stuff. It should be brought up so that you can at least be thinking about it. And if you don't want to do anything with it, fine, but you should at least know that as a buyer so that if you are later in life, maybe you should think about, okay, what should I do for estate planning purposes in case something happens to us? And that's more to protect that asset and to make sure you're not giving the government more of your money. So again, you can reach out to us if you have questions about this. But really, if you want a definitive answer, I can give you like what each one means and what I think. But really, based on your specific situation, I would have to see everything, your financials, all of that. So you should be talking to either an estate attorney or an estate planner. But again, you can text or email or call us 608-576-0044 or email us tj@srehelp.com. Don't forget to raise your standard, and we'll talk to you soon.